I'm going to change the facts a little to protect the identities of the innocent. I've been working with a client for multiple years. In 2009, her father transferred her grandmother's home under a power of attorney to her father. The grandmother wanted this to happen. She told multiple people about her intention that this was her wishes. My client's father went to an attorney who prepared the power of attorney 5 years earlier. That attorney drafted the deed, helped my client's father sign it, and recorded it at the Registry of Deeds. Fast forward to 2024, after both the grandmother and the father had passed away. When the client went to sell the property, she wasn't able to. The buyer's title company came back with a litany of problems. The POA didn't explicitly authorize self-dealing. The attorney didn't prepare an affidavit of power of attorney to record with the deed. The deed granting clause incorrectly included the power of attorney's name. The signature line arguably didn't comply with land court guidelines, and the acknowledgement was arguably defective. So the result is, we had to file a lawsuit in the land court, and now the estranged members of the extended family have potential legal claims to a large fraction of the home's value. That attorney is now retired in Florida, has none of his client files, and gets to forget about the mess that he caused. He completely shanked this file. And the worst part is that the grandfather had a revocable trust that could have been funded. That case is still active today. I'm going to tell you exactly how we got here, and more importantly, I'm going to show you how to make sure that this never happens to you or your family. And this got me thinking, what are the most common ways that lawyers make title mistakes? And if you own real estate, you're thinking about putting your home into a trust, I need you to hear this. Having a trust and having a funded trust are two completely different things. Right now, there are homeowners just like you with a complete false sense of security because their attorney made one of the 5 very common mistakes that cause real estate title problems. In this video, I'm going to show you exactly what those mistakes are, what they cost families, and what you can do about it. And stick around to the end. I'm going to walk you through the exact 5-step process that we use when reviewing a new client's real estate situation, so you know exactly what to look for before these problems ever surface. So the problem is that estate planning and real estate title work are two different disciplines, and when the attorney handling your estate plan doesn't have deep real estate expertise, things can fall through the cracks. And those cracks become your family's problem. My name is Ben Cote, and I run Cote Law Group, where we sit at the intersection of real estate law and estate planning. I help families protect everything that they've built by making real estate and estate planning simple, so nothing gets left behind. I see these title problems regularly on actual transactions, on actual properties with actual people. These problems are easily avoidable if you work with the right attorney. So let me walk you through the 5 mistakes that we see most often. And stick around to the end of the video and I'll show you exactly what a real estate attorney should be doing when they're working with a new client so you know the right questions to ask. Mistake number 1, the trust isn't funded. This is the most common mistake that we see, and it's exactly what happened in the story that I just told you about. The attorney drafts a beautiful trust document. You sign it, file it away, and you feel completely protected. But if the deed was never updated to reflect the trust as the owner, the property is not in the trust. When you pass away, your family is looking at a full probate proceeding, which can take months, cost thousands of dollars, and is an entirely public process. And for married couples who include exemption planning in their trust, this means that hundreds of thousands of dollars are missed. Better yet, you can open the Registry of Deeds website, search your name, and verify that the transfer actually happened like you think it did. Here's something that surprises people. Mistake number 2 can happen even when the trust is funded. I've seen it happen many times. And mistake number 2 is, some of the land is missing. You might own multiple parcels, maybe a primary parcel and a small adjacent lot that you bought years ago that's on a separate deed from when you purchased your home. An attorney without strong real estate experience might only transfer one parcel and miss the other one entirely. So now, part of your estate passes through the trust cleanly, and part of it gets stuck in probate. It creates a legal mess that's expensive to untangle, and it could have been completely avoided with proper due diligence up front. That brings us to mistake number 3. This one happens even when the trust is properly funded and every parcel has been transferred. Mistake number 3 is there are no successor trustees named in the trust. A trust needs someone to manage it when you're no longer able to, whether due to incapacity or death. Some estate planning attorneys simply forget to name a successor, or they only name one without a backup. When that trustee can no longer serve and there's no designated successor, your family has to go back to court to appoint one unless the trust is drafted in a very particular way. Even if there is a successor trustee, some estate planning lawyers don't know to include the successor trustee's name in the notice of trust recorded at the Registry of Deeds. This can cause additional problems that sometimes require a court to fix the original trust if it's lost or misplaced. More delays cause more legal fees, causes more family stress during an already difficult time. Which brings us to mistake number 4, which is one that most people don't see coming until it's already too late to fix it inexpensively. And that's by doing an informal probate without a determination of heirs. When somebody dies without a will, the family has to go to probate court to determine who the legal heirs are. But not all probate proceedings are created equal. An informal probate doesn't result in a formal determination of heirs. That means that down the road, when your family tries to sell or refinance the property, a title company may require an additional court order to confirm who actually owns the property. If the attorney handling probate doesn't understand the realities of real estate law, they may give bad advice and select the wrong type of probate at the beginning. And that's another round of legal expenses that could have been avoided if the right type of proceeding had been used from the start. And the 5th mistake, this one isn't technically a title problem, but it may be the most expensive mistake on the list. And that's transferring the property directly to the kids during the client's lifetime. Now, this isn't a title problem, it's a tax problem, but it's one that can cost your family a significant amount of money. When you transfer real estate to your kids outright, they inherit your original cost basis, not the stepped up basis they would have received if the property had passed at your death. So when the kids eventually sell, they're paying capital gains on decades of appreciation that could have been completely shielded with the right estate planning structure. We see this most often when real estate lawyers without estate planning backgrounds transfer property this way without realizing the tax mess that they're creating for the family. Do you remember the case that I opened with? An attorney transferred a home using a power of attorney and made 5 separate technical errors in the paperwork. The grandmother is gone, the father's gone, so we have very limited witnesses as to what actually happened and what the intent was. And my client is now in litigation, fighting to hold on to a home that was always meant to be hers, while estranged family members of the extended family make claims to a significant fraction of the value. All of it was caused by a single attorney who didn't have the right combination of real estate and estate planning expertise. And that's what's at stake here. And that's exactly why working with the right attorney matters. So here's the bottom line. Your home is likely one of the most valuable things that you own, and your estate plan sitting in your filing cabinet might not be protecting it the way that you think. Not because you did it wrong, but because the pieces may not have been put together correctly. Real estate title work and estate planning need to be handled by somebody who understands both. When they're not, it's your family that pays the price. If you own real estate and you're not 100% sure that you have those 5 boxes checked off, let's talk. Remember how I mentioned that I would tell you how a real estate attorney actually reviews for these issues? I'll tackle that next as soon as I mention that at Cote Law Group, we offer complimentary consultations. We'll review your situation, flag any issues we see, and make sure everything is properly structured before it becomes someone else's problem to untangle. Visit us at cote-law.com to schedule a consultation or reach out directly. The link is in the comments. So how does a real estate attorney actually review for these issues when they start working with a new client? It comes down to 5 steps, and most of them happen before we even open the trust document to take a look at it. Step number 1, we ask for your name and address. It's simple, but that's where everything starts. Step number 2, we pull up the GIS map to see the actual shape of the lot that the town thinks you own. This is not what you think you own, it's what the town has on record. Step 3, we review the tax card and pull the deed that's referenced on it. Step 4, we match the deed back to the tax card and verify ownership. We want to make sure that there aren't any other deeds or any other missing parcels that we might be missing. And this is where the first cracks usually appear. Step 5, we review the recorded plan and compare it to what we saw in the GIS map. If those 2 things don't match, we have a problem. And finally, we check the registered land system to make sure that there aren't any additional deeds sitting in the land court, meaning that the property is what we would call both systems. Most estate planning attorneys never do any of this. They draft the trust, hand you the documents, and call it done. And that's exactly how title problems get created, and exactly why picking the right attorney matters. If you want a detailed video on how to review this yourself, leave a comment below. And if this video was useful, share it with a family member or a friend who owns real estate. The more people who understand these issues, the better protected all of our families will be. I'll see you in the next one.